All right. Good morning, everyone. Or I guess afternoon, depending on where you're at. My name is Lisa Thompson, and we are going to talk about the biggest mistakes business owners make in the life cycle of a business. Um, Here's my contact information. You're welcome to reach out to me. I am licensed in California, Arizona, Nevada, and Washington, D.C. And in October, I will have been practicing business law for 30 years. But I do stay current. And a lot of what you're going to see is what I've learned and what I've written about in my practice. So, um, kind of my housekeeping for today. So, this seminar applies to all businesses, professional corporations, limited partnerships, limited liability partnerships, and limited liability limited partnerships, professional LLCs, and LLCs, which are limited liability companies. However, the most prevalent business entity right now is the LLC. So I'm going to probably be referencing just LLCs, and I will say the word company. Um, I'm talking about LLCs. It applies to all business entities when I say company. If there's something specific to a certain type of business entity, I will reference that. And when I'm saying you, it really means the business, or it means the business owner, or it means you. But it's just easier for me to do it that way. So today I want to discuss the common mistakes that I see, and attorneys, my colleagues actually make these mistakes as well. So I don't mean to call anyone out. My goal is to um, give you some things to think about, and if there may be things that you need to change with your business structure, that you do it now, because it is way more difficult and costly to do it when it's a problem. And sometimes it cannot be changed. Like in the situation of succession planning, if you're in the situation where you didn't make an exit strategy for your company, by the time you need it, generally it's too late. So I'm hoping that this prompts you to think about some things that might be lacking in your structure and fix them now, and reach out to anyone that, to your qualified business law attorney, to your tax professional, and make sure that everything is set up as it should be for your business. So again, mistakes happened, and we're going to try to avoid them with this seminar today. All right. So the overall business owner mistake that I see is failure to have a plan. And my dad always said, this was at the dinner table, like for my entire lifetime, his preaching was always have a plan. It could be a bad plan, but plans can change, and if you have one, you're good. And he thought that that always moved you forward, and it kept you thinking about your circumstances. He was an industrial engineer, so there were a lot of, when I was planning to go to college or to law school, he made graphs and formulas to determine where I should go to school. But he was always about, have a plan, because that moves you forward. And I think that that translates to businesses. You always need to be considering what your plan is. And I'm not talking necessarily about having, massive financials, or anything that's, like 70 pages long, but you need to be thinking about, where are you going to be in a year? Where are you going to be in 2 years? What happens if? Which goes to his second thing that he said, which, by the way, he doesn't remember saying any of these at all. And I mentioned it to him. I said, I call you out in my seminars quite frequently. And I said, well, you always say this. And he goes, nah, I never said that. And my mom was like, yes, you did. So we're all good. But his other comment was always, get comfortable with your worst case scenario, right? If you are comfortable with whatever the worst case in your mind is, then everything else is gravy. And if you're comfortable with your worst case scenario and it happens, you're already prepared for it and it's not so bad. So you always need to be looking at where do you want to be, best case scenario, but also what's the worst case scenario and how can you prepare for it, um, hoping that it never happens. So, um, bad plans really happen from having no plan. You're going to have to pivot with what you're doing, but you should always have some type of plan. There's a lot of really good business resources at the Arizona Small Business Development Center. I put the link in below. They have a small business development center in Nevada, California, I think all states, but I know all the states that I practice in, they have them. And they have a ton of free resources that are super helpful. And sometimes they even will provide coaching on the financial aspects of your business. So it's a good place to look and just kind of see what's out there. All right. You need a plan for the beginning, middle, and end. So here are your mistakes at the beginning, or at least the ones that I see. So failure to have a professional team. Excuse me. Create your team from the beginning. Um, I'm going to say this, a lot of what I talk about is, from a legal perspective, but a lot of it is because I did it wrong and I am trying to keep you from doing it wrong. So I do not come preaching at you from on high. I've been a small business owner and I did things myself and I didn't know what I was doing. And I wish I would have done these things. And from the beginning, even myself, I was a brand new attorney when I started practicing. And I should have talked to a qualified business law attorney. And when I say qualified, and I put qualified for both business law attorney and tax professional, I'm talking someone who does this type of work on the regular. Like this is what they do, not an attorney that can handle, a sole practitioner who can handle, a DUI, a will, business setup, personal injury. Like that is a jack of all trades and a master of nothing. If you're at a big firm, sometimes they can be a one-stop shop, but you really want to get someone that this is what they do. You also want to get a qualified tax professional. Um, to really guide you from the beginning as to, if you're an LLC, you need to know how, what election you need. How should you be taxed? How can you minimize your tax liability for your business? I think I still have a bald spot from when I finally got a qualified tax professional and learned all the things that I had done wrong with payroll and all of that. So it's key. I'm not sure if the attorney is the chicken or the egg or the tax professional is the chicken or the egg, but you need both. I do think that there are other people you should have on your team, but these are critical. And if you work with me, I will at least make you go away and lie to me and tell me that you talked to a tax professional because every single thing that we do, it's all interconnected. So every legal action has a tax consequence, or generally it does. So you always want to be checking, and I want, you know, the decisions that we make for you legally to be checked by the tax professional. And your tax professional probably wants, tax strategy checked by a qualified business law attorney. So again, you really want to keep all of that in mind, whether you're thinking about an exit strategy or you want to sell your business or you're doing some type of contract. You always want to, get someone in the field that's a professional who does this to say, yeah, that's okay. I mean, that's my favorite doctor's appointment is when I go to the doctor and say, okay, there's this. And they're like, you're good. And I'm like, I will happily pay you your copay for that because I want to know that I'm in the right place and I'm doing the right things. All right. So failure to set your business up properly at the beginning. Um, there are And I think in large part it's because of my profession. I think that everybody thinks that, attorneys charge a gazillion dollars. Um, and that's not the case. I can't speak for all of my colleagues, but I think that there's this idea that I'm starting a business. I don't have that much money, and I'm worried that if I talk to an attorney, I, it's going to be tons and tons of money. Um, I think you should shop around and you should see what you can find out. A lot of people go to third-party filers, and by third-party filers, I'm talking about a service that says we can form your LLC or your corporation for, $300 plus the filing fees. And there's no magic really to forming an LLC. We could all do one right now. It's knowing what should be in it and how it should be structured. And so, you know, when you go to a third party filer, they say, here's our questionnaire. What do you want? And you're basically making the decisions for yourself. So if there is a mistake, there's no insurance, there's no malpractice insurance. They also don't explain to you what you have. I can't tell you the number of times that I have folks come to me and I'm like, well, one, we are locked out from doing anything on your business because we didn't form it and we have to go and get permission from the company to be an authorized filer with the Corporation Commission. And that just happens. So they're not, I'm not saying that they have some sinister motive about it. But you do have to go to them and say, I need to be an authorized filer so that I can, file electronically to change my address or do whatever I need to do. But they also set themselves up as your statutory agent. And that's going to be a recurring expense, which is completely fine if you understand what a statutory agent is and that you're going to be charged for that annually. And we're going to talk more about statutory agents in a minute. And so you end up with a bunch of documents and you may or may not know what you get. I always recommend, if you want to set up your LLC for yourself, by all means, but talk to your qualified business law attorney, and find out what your structure should be. And then you can go do it for yourself if that is what you want to do, if you think that that will save you some money. I'm also not suggesting that, when you have a qualified tax professional, that you need someone to run your books, because that can get expensive. What you need is to have a relationship. So when you have questions, when you need to get your taxes done, you're set up to be doing it appropriately. And then, bring your professionals in as you need them. All right, this is the biggest one for me, is failure for LLCs to be manager managed. Owners need to maintain the control of the company no matter what happens, or they need to make educated decisions to give up control. And so here's what happens is when you go to the third party filer or you're filing for yourself, um, or even if you have your CPA file, create your LLC for you, um, you're, and it's a single member or it's you and your spouse. Um, there's two types of ways that LLCs can be managed. One is member managed, and the other is manager managed. And the members of an LLC are owners. So if you're member managed, that means anybody who's an owner can manage the business. And if you're manager managed, it means that you have your members who are the owners, and they aren't necessarily the managers, and only the managers can run the business and make the decisions about the business. And what people don't understand is a member can also be a manager, and a manager does not have to be an owner. So what most folks do when they're going to be a single member LLC or they're going to be, it's two spouses, they say, well, we're going to be the owner, so let's just be member managed. But what they don't realize is that they are setting themselves up for potentially a creditor to reverse pierce the corporate shield. And so if you are member managed and something happens and you personally are being sued or you have a creditor coming after you, your ownership interest in the LLC is personal property, and a creditor can come and take that. I did collections for years, and folks that owned rental properties, and they had them in their LLCs and they were member managed. There were times where we would attempt to take the ownership interest of the LLC. And if that happens and you are member managed, then you've got a creditor that just took over your LLC and can control it. But if you're manager managed, you can have an operating agreement, and you should have an operating agreement that says only managers make management decisions for the LLC, and you can keep anyone who takes an ownership interest in your business from being able to do anything with it. Now, again, this happens infrequently, but if it does happen, you can't fix it. At the point that it's happening, you're not going to be able to fix this. And so it's such an easy fix to change your management structure to be manager managed. There's no reason why you shouldn't. And a lot of my clients will say, well, I'm just going to be a single member. It doesn't matter. Well, one, you want to protect against piercing the corporate veil. But two, you also want to show that you are running your business separate and apart from yourself. So having an operating agreement, even if it's an operating agreement with yourself, allows you to show, look, I do the formalities of being an LLC. So, for example, I'm a corporation and I'm a one-person corporation. So I am all of the officers in my business. I am the shareholder of my business, and I am also the board of directors. And the law in Arizona says that you must have annual meetings with your shareholders to elect the board of directors, and then you must have a meeting of the board of directors annually so that you can elect the officers. Okay, it's just me. So my shareholders, me, get together on Cinco de Mayo and we vote in the board of directors. And guess what? I win that election. And then my board of directors, again, me, votes for the president, president, secretary, and treasurer of my corporation. And again, that's me. And really, it's me sitting at my computer on Cinco de Mayo typing change 2024 to 2025. So I have annual meeting minutes. So if anybody ever comes after me and says, well, you didn't treat your business as you should. You treated it as a toy, and we're going to disregard it. We're going to pierce the corporate veil, and we're going to come after you personally. Can be like, look, I did everything that I could. I followed all of the formalities, even though they seemed silly. So if you're going to have the protection, you should make sure that you do every formal thing that you can to prove that your business is separate and apart from you. And we're also going to talk a little bit more about those things in a minute. All right, failure to have an operating agreement. Your operating agreement is a written internal governing document. Now, it doesn't help to have an operating agreement that's not signed. You've got to sign it. Everybody's got to agree to it. And it says this is how we run our company. The managers do X. The managers are not authorized to do this other thing without permission of the owners. You can write whatever you want, but you need to have something. And again, you need to make sure that it's signed. You need to make sure that everybody has a copy of it. It will allow you, well, banks sometimes ask for it, even though it's not a requirement in the state of Arizona, but it also will detail your succession plan, your exit strategy. It also shows the ownership of your company. Because if you look at the Arizona Corporation Commission, public records do not show the ownership of your LLC. The only thing that you are required to provide is any owner that owns 20% of more of your company. Now, for corporations, it's not an operating agreement, it's bylaws, and you are required to have them. And again, it's a written internal governing document that's signed. We just for LLCs call it an operating agreement. All right. You got to have a succession plan in your operating agreement or in your bylaws or as a separate document. You want to make sure that you know how to prepare for the worst case scenario, how you can get out, but also sometimes you're preparing for the good. Um, a succession plan is just an exit strategy. It's a plan for the what ifs. It also will allow you to, discuss what happens if you're temporarily unavailable. What happens if you die? What happens if someone in your business wants to leave? What is the buyout? So you want to look at those things. They, there's no I think people get overwhelmed by creating their succession plan. They're not one size fits all. What works for one may not work for you, but it's about really thinking through what it is that you want. And I have clients that will consult with me and we're going to do their operating agreement. We talk about various options and then crickets chirp and I have to hunt them down. And I think a lot of it is not because they don't want to have an operating agreement. They just are like, I don't know how to decide. Um, so I've started just writing an operating agreement so they can be like, no, we don't like that. Because then it makes it easier to choose. All right. So again, contemplate divorce, death, disability, destruction, and dissolution. You want to think about, what happens if you have owners of the company that get divorced. What happens if you both, both spouses own the company and you get divorced? What happens if someone dies? What happens if someone's disabled? What happens? Well, I threw in destruction because it sounded good, but you do want to think about like what happens if everything goes down badly. Dissolution is how do you dissolve if you need to. Um, excuse me, creditors, it will, you want to talk about how you're keeping the management at the management level and not at the ownership level. You want to make sure that if something happens to you, your business will continue on. And again, I told you I'm a sole proprietor or I'm a sole practitioner in the sense that I'm only one person in my corporation. And I lived in fear for a long time as to what happens, to my business, to my clients, if it's just me. And, I have come up with a succession plan so that there are things in place to make sure that my clients are taken care of if I am either temporarily or permanently unable to manage my business. Um, you want to think about what happens if you want to retire or if you want to sell your business. You want to position yourself correctly. Um, and you want to be ready for due diligence. It's amazing to me when I'm doing buy sell agreements and whether I'm on the buyer side or I'm on the seller side that um, you know, like, do you have meeting minutes? And, I'll have corporations look at me like, what? Meeting minutes? Oh, well, you're supposed to have a meeting every year. Like, did you document that? Or, addresses aren't correct with the Corporation Commission or any of those types of things. You want to make sure that you're positioning yourself to show that, you ran your business well and that it's in a good position to either sell its assets or to sell the business itself. So these are the things that you might want to think about if you're temporarily unable to run your company. Do you want to have signers on your bank account? Other signers? Do you want to have a power of attorney? If you do have a power of attorney, you want to talk to your bank and make sure it comports with what your bank likes, because sometimes they're really funky about what You can have a great power of attorney and the bank's like, yeah, no, we want the one that's on our blue paper. So you want to check into that. Do you have another manager? Do you have backup? If your business is owned by a trust, which actually is an incredibly good idea if you need a trust for other reasons, do you have language in your trust to deal with that? Do you have language in your trust that allows you to put someone in temporarily into your company if you're unable to do the things that you need to? And then what happens if you die? I just consulted on um, a colleague of mine contacted me, and the situation is there was a business owner who he and his spouse created a trust. They were going to have the trust own his portion of the business, which was 96% of a multi-million dollar LLC here in Tucson, and there was a 4% owner as well. And they didn't go and do an operating agreement to change it to the trust. There was no documentation filed with the Corporation Commission. Nothing was done to transfer the ownership of or his ownership in the business to the trust. The operating agreement said that it was member managed. Apparently, the 4% owner of the business, he really was just the money person, and the business was just member managed. And the 96% owner went on vacation and died. And now the 4% owner is like, I think I'm going to run it. And the spouse can't do anything about it. And so it's a huge, big problem. And this was not an older person. This was someone who got in an accident on vacation. He left his spouse and his family with a problem because now they have to go through a probate, and they were trying to avoid that with their trust. And they have an owner that was really supposed to be the money person and doesn't know anything about managing the business, who's like, well, I'm going to manage it now. So you really want to think about those things, and you want to make sure that your ownership interest either passes to your heirs or they're compensated for it. You can, with LLCs, have them owned as joint tenants with right of survivorship, which means if something happens it's only if, humans own it, not other businesses. So I wasn't being funny with humans. Legally, we consider individuals to be other business entities. So it's got to be humans. They can own the business or their interests as joint tenants. And so if one owner dies, the other owner automatically owns the entire business. It's much like, if you own a house, if you own it as joint tenants with right of survivorship, if something happens to one person, it automatically passes to the other. Um, but if you do that, you want to have some provisions in your operating agreement that discuss how the estate of the deceased owner gets compensated for the ownership interest. And that can be done with life insurance. It can be done with, well, we're going to value the business, and, whatever the deceased owner's membership interest is, we're going to pay that amount over a period of time. And those are things that you can put in your operating agreement, a separate agreement, or in your bylaws. Can also own LLCs with community property with right of survivorship, which is just the same as what I discussed with you, but it's with two spouses instead of just two human individuals. All right. You can also, as I mentioned, have your LLC or your corporation owned by trust. This works if you are a professional limited liability company or a professional corporation. There's no problem with that, so long as the licensed professional in your professional business, in fact, is part of the trust, and it is a revocable trust. So it's a really good way to own a business because you can deal with how it's going to pass through your trust, but you need to make sure that this is reflected with the Corporation Commission. Just assigning it to, I've talked to several estate planning attorneys and like, well, we just assign the interest to the trust. That's not that's not good enough. Especially when filing articles of amendment with the Corporation Commission to change the ownership would fix it. You should go ahead and do that. You just want to make sure that you've protected your family and that everything is done that should be. And I'm also not suggesting you get a trust just to own your business. But if you need one for estate planning purposes for other reasons, then by all means, think about having your business owned by your trust. Okay, here are some other operating agreement clauses to consider. Again, buyout provisions. You're gonna love hearts, flowers. When you go into business with someone, um, you know, it's great. Nobody thinks about when either one, you don't get along, or two, someone just wants to leave and they just don't want to do it anymore. You need to talk about how you're going to buy each other out at the beginning. No one gets into business so that they're going to get out. But you do need to think about it because it does happen. It's just like nobody gets married to get divorced. You need to think about these things for your business at the beginning when everyone gets along. And I think one of the biggest problems is trying to figure out how to value the business. If it owns rental property or any type of real property, it's easy. Not so easy if it doesn't. And you also want to think about, in the event of death, does the ownership interest pass to a spouse? Or, if there's a divorce, how do you deal with those types of things? And again, no right or wrong answer, just things to think about. You should also think about dispute resolution clauses, because you may not always get along. And, what happens if you're in a stalemate? What happens if there's only two of you and you ardently disagree? Do you want to put in a mediation clause so that you force yourselves to go sit with a third party neutral to, come to some kind of resolution? Do you want to do an arbitration? How is it that you're going to resolve your disputes? And because you want your business to continue on. But if you're mad, sometimes we aren't all that reasonable when we're mad. So you might want to think about that or have, designate someone that has the final say on any argument. All right, voting provisions are critical. As you sit here today, do you know how you can vote in your LLC or your corporation? If you're a single member, you're good. If it's spouses, you're probably okay. But you want to know what your vote is. Do certain decisions need to be unanimous? Are they just a majority of interest? Do you get to vote your percentage interest in the LLC, or does everyone just get one vote? If you do not designate these things, you're going to be stuck with the default provisions of the law. And you need to know what those are because you may not like them. And for a while, it was if you were an LLC, each member of the LLC got one vote and it didn't matter their ownership percentage. So that's crazy, right? If you have a 96% owner and you have a 4% owner, they each get one vote. That doesn't seem fair. But if you don't have an operating agreement and you don't specify what you want, that could be a problem. So you need to think about the voting. All right. Failure to maintain your statutory agent or keep your statutory agent updated. Um, Last year, I did a lot of work with LLCs and corporations with some compliance issues, and I was amazed at my favorite one was the statutory agent that was a CPA who had died 8 years ago that was still listed on my client's active business. Your statutory agent is the person, and it needs to be a person or a service that is designated to accept legal documents on behalf of your company. So think about this. If you were going to sue McDonald's because you got a bad Big Mac and it made you sick, and you're like, I need to sue McDonald's. Well, how do you serve the paperwork? And by serving, I'm talking about when you see in the movies like, Hi, are you Lisa Thompson? You've been served. That kind of service of process. The statutory agent is the person designated to do that. So if you're suing McDonald's, like, what do? You go through the drive-through, you give it to them, you're like, hey, you've been served. Ronald McDonald, any of those people? No. You go and you look at the Corporation Commission, you find out who the statutory agent is, and that's the person that you serve with paperwork. That's where you mail any legal correspondence. Every other state in the nation calls the statutory agent the resident agent. Arizona is just special. And so we say statutory agent. But if you're familiar with the term registered agent, it's the same thing. Your statutory agent can be you. And in fact, I recommend that. Um, there's no qualification to be a statutory agent. You need to be over 18, you need to breathe, and you need to be located in the state of Arizona if you're the statutory agent for an Arizona business. Or if you're in Nevada, you need to be located in Nevada. Um, if your statutory agent is not you, then you want a service that's dedicated to being a service of process company for sure. You don't want your CPA, and you don't necessarily want your attorney unless that's what they are set up to do. Um, you can, and you want to make a decision about your statutory agent. Don't make it a one-off. I had one guy where I said, you should be your statutory agent. He's like, I don't trust me. And I was like, okay, well, we can set you up with a service. He's like, well, I don't want to do that. And I was like, well, who do you want your statutory agent to be? And he's like, my mom. So his mom was his statutory agent. So there are services out there. The one that I use that should start giving me kickbacks because I refer them a ton of business is $49 a year, and they will be your statutory agent. Fantastic. You cannot beat that. Now, if you use a third party company, or that to set up your business, they will automatically put themselves in as your statutory agent. They will not explain to you that you can make a choice. And they're charging, I think, from the last one that I saw this week, like $200. That's how they make their money. So, and it's really hard to get out of their, to like kill it off. I just, um, put my clients in or change the service so we don't have to go through them to deal with it. All right. Another big mistake that is made is failure to understand personal guarantees. So when you have a business, you are not responsible. Like, one of the reasons why you have an LLC or a corporation is to have that big veil that protects you. So, like, nobody can come after you personally. Now, reverse piercing the corporate veil is when you've got someone coming after you personally that has nothing to do with your business. But anything dealing with your business, you are protected unless you sign a personal guarantee. So, as a matter of law, the law states that if you are a member or a manager or a board of director or a shareholder or an officer in either an LLC or a corporation, that you are not responsible for the business's debts. However, if you sign a personal guarantee and the business does not pay the debt, then you are responsible. So, if the business fails, you have a lot of business owners that are personally responsible for paying the debt. Now, if you are a new business, there are very few companies that are going to loan any money to your business unless you sign a personal guarantee. I'm not saying don't sign personal guarantees. It's always awesome not to, but it is very rare that you don't have to. My point is be educated about it and understand that if things go badly, that will be an issue. And you might want to also address it in your operating agreement or your bylaws because maybe only one owner has to sign the personal guarantee. And if that owner leaves, are the other owners going to pay back? What is the situation with that? All right. Here's some mistakes in the middle. Failure to follow corporate formalities, making sure your business address is updated, making sure that you've kept things accurate with your public records. And this is kind of where I break it down. You should use the proper terminology for your business. You should also use your correct legal name. And I am sure some of you are smiling and laughing. It happens more often than you think. I have an intake and I ask people like, what is your business name? And they get it wrong. Um, you know, so you really, if you want to have the protection of your business, you've got to use the business name. You need to sign documents using your legal title. Um, with LLCs, if you are member managed, you sign as the member. If you are manager managed, you sign as the manager. Not sexy terms, but those are the terms that are used. And we do not have presidents of LLCs in Arizona. And in fact, when I hear someone say that, I think, wow, they really don't know their business. What else do they not know? So if you want to call yourself the principal and or founder on your business cards or anything else on your business cards, great. Probably don't want to use corporate terminology. Excuse me. Um, but when you're signing legal documents, use the actual title, that the law has given for that. And keep in mind also, like in I think it's Minnesota. In Minnesota, they do have presidents of LLCs. So that's appropriate there. So all of this is based on state, but most states, at least where I practice, it's members and managers for LLCs. But some of the states back east are president. I mean, you could be CEO, that's great. But on your legal document, if you are the manager of a manager managed LLC, then you need to sign with the term manager, even if it's not sexy. Um, Use your EIN. The EIN is the social security number for your business. Do not use your social security number for anything other than getting your EIN. And also, if you sell your business, um, you should make sure that the responsibility for your EIN gets passed to the new owners. Um, you want to keep your personal and business funds separate. Don't commingle them. We're going to talk a little bit more about that. That's the big one. And if you've got a creditor trying to pierce the corporate veil and come after you personally for something, for a claim against the business, they are going to look at what you did with your money. And they're going to argue if you were paying, if you're mixing everything together, that you weren't treating your company as separate and apart from you. Again, keep your records up to date. You should also know your passwords for all your business accounts and software. That's not really a legal thing, but if you have someone leave, that can be problematic for you. So it is something that you need to do and make a point of. All right. This happens a lot with small business owners, and it kind of goes back to the commingling that I was talking about. It's like, well, it's just me. So why can't I pay my mortgage out of my business account? Here's the deal. If you own stock in IBM and you were the owner of IBM, would IBM pay your mortgage out of its bank account? It would not. Now, if you got money from your stock in IBM and it went into your bank account, then you could pay your mortgage out of your bank account. It is fine to use the money in your business to pay your personal expenses. You work for your business, whether you are an employee or a 1099, independent contractor to your business, or you just get draws or distributions. All of that is fine. But put them into your business account or into your personal account first, then pay your personal expenses. If you have a problem determining what you should do, pretend that you do not own the business. Pretend that you are just an employee. If you're an employee of IBM or McDonald's, would you be able to pay your mortgage out of the business account? You could not. If you are the owner of a company, like if you need to make a lot of people think that they can use their business and write off everything. Like, I'm going to buy a car in my business name and I'm going to write that off. Well, maybe you can write off part of it. Maybe it is appropriate for your business. Maybe it's not. That would be something that you might want to talk to your qualified tax professional about before you do it. All right. Annually, you want to check in with your people. You want to make sure that the contract that you drafted in 1982 or the contract you drafted in 2023 is up to date for 2025. You're going to be talking to, hopefully, your qualified tax professional because you're going to do your taxes each year. But it's good to check in or get on a plan with them so that you are checking in so you're not shocked in March or April whenever your taxes are due. Um, but also think about your business law attorney. You know, here are my forms that I'm using. Has anything changed? You also want to make sure that you're working with someone that's going to keep you up to date. Like if something changes, they're going to let you know, like, hey, the big, beautiful tax bill, it affects you this way. Or, hey, the Corporate Transparency Act is back. You need to do this. You want to make sure that you're working with a team of professionals that will keep you updated. Or they they don't necessarily have a duty to always tell you what's going on unless you have an ongoing relationship with them. But if they have a blog or they have anything where you can be getting information, you need to stay up to date on that type of information. All right. Don't be afraid to get other professionals involved. One of the big ones I'm seeing is folks aren't protecting their brand. They're not talking to an intellectual property attorney. I'm going to say qualified intellectual property attorney. That would not be me. I do a ton of business law, but intellectual property is not in my lane, except for the very basic. You need a trade name with the Arizona Secretary of State. And even then, I'm going to make you talk to someone who knows national branding. And you want to do this at the beginning. I'm saying in the middle. You want to have a good insurance person. You really want to talk to a human resources specialist if you're handling, you don't need to have someone full time, but you do need to make sure that you're doing things correctly. I know this because I have not in the past. All right. And any other professionals that you need. So, mistakes at the end. The end can be good or bad, but the biggest mistake is failure to shut down your business appropriately. I can't tell you the number of times that I've seen people and they're like, "Oh yeah, no, my business is shut down." But it's still active with the Corporation Commission. It's still out there. Um, if you're shutting your business down, whether you sold all of its assets and you're not going to use it anymore, or you need to dissolve it, you need to shut it down. And the Corporation Commission is actually going to start in January of 2026, reaching out to LLCs and saying, hey, are you still doing something? Because we haven't heard from you in 2 years. And you can have an active LLC and be running it and not be filing anything with the Corporation Commission because we do not have annual reporting requirements like California or Nevada or pretty much any other state. Like Arizona, you form your LLC, and so long as you don't move and your statutory agent doesn't retire or doesn't resign, there's nothing for you to do annually. So a lot of times your LLC can be completely up to date and you haven't filed anything with the Corporation Commission for years, but you are going to start being asked every 2 years if you're still active. So you want to shut down your business uh, if it's no longer operating. And one of the reasons for this is if it's no longer operating and it's just hanging out there and you're not paying attention to it, there is a big move by scam artists to start um, picking up where it left off. And you might not even know about it. So you want to make sure that you shut it down. And you can even cancel your EIN if you want. It's not required, but you might want to think about that again because uh, there are tons and tons of scams out there. And the other thing on that note is if you do form your own business, if you go and you do the paperwork yourself, I have been shocked by the blatant notices that you will get. So you will get things in the mail saying, and it will look like it's from the Corporation Commission, and it will say, you need to get your certificate of good standing. Okay, first of all, you don't. Second of all, the Corporation Commission, like never sends you anything by mail. Pretty much never, ever, ever. So it's completely wrong. I'm sure that they will get you your certificate of good standing if you pay them $58.75, but you could get it online for $10 and you just simply don't need to do that, especially if you just formed your business. I just formed a business and so you ACC is not going to send you anything. The IRS is not going to send you anything. If you do get something that you think is from the IRS, contact your tax professional. If you do get something, if you're working with an attorney on your business, like don't pay money out for business stuff unless you ask. And make sure that it is not a scam because they look good. But this is my favorite one. I just formed a nonprofit this last week and it was approved. And for various reasons, I'm listed as a statutory agent temporarily. And so I'm a statutory agent. It got approved. I got the email notice from the Corporation Commission saying, yay, you were approved. And so your business entity is set up. And within a day, I received a text message from a company called einapplications.org that said, yay, your nonprofit was formed. We can get your EIN. You need to get an EIN. Please contact us. And I'm sure that if I contacted them, well, I'm not sure they would take a bunch of my client's information or my information and they might do nefarious things with it. Or they might give me an EIN for a fee. You do not have to pay a fee to get an EIN. You can go to irs.gov, you can get it immediately, but you can only get it during the weekdays, during business hours with the IRS, because apparently you cannot get electronic EINs over the weekend because the computers need to sleep. Um, so watch out for scams on this. And you do want to be watching your company with the Corporation Commission. Not only do you want to make sure that it's updated, you also want to make sure that someone doesn't update it for you. Because I can go sign documents for any company as the authorized agent. So there are a lot of people that aren't so honorable and have been making changes to entities that either are operating or are dissolved. So you want to be paying attention to these things. I know it's annoying, but you really don't want to have to be the cautionary tale. And with that, if I can ever be of service, I have a lot of information on business on my website in the frequently asked questions. I talk about a lot of this stuff. I am updating my blog, so it's a little bit behind at the moment, but you can subscribe for updates. I do send around email blasts if there's something in the law that has changed that will affect business owners. I do it judiciously. I do not bombard people. I will put most things in my blog, so if you want to pay attention to that, that's where you will get things. I only use my email blasts for things that are vitally important to most businesses, or if there's some announcement that I need to make. Well, thank you everyone for listening to me for an hour. I greatly appreciate it. I wish you all the best with your businesses and have a great day.